Thank you all so much for joining us today. My name's Emily Kile, and we're going to talk today about guardianship, conservatorship, and I said powers of attorney, but we're really going to talk about two alternatives, powers of attorney and something called supported decision making. We'll get to those at the end. If you have questions, if you could type them into either the Q&A or the chat box. My goal would be to stop after each of the topics. It's hard for me to coordinate otherwise, so I will read those questions if there are any when we get to the end of each of those sections. You should have gotten a copy of the PowerPoint. If not, and you'd like it, by all means, just contact the office and we're happy to provide that to you so you'll have it for future reference. Remember that I'm not giving anybody legal advice. I don't know what your specific situation is, so this is really an overview, and if you need legal help, I'm happy to help, or of course any of the other attorneys in town that you may know or may want to know can help you with these kinds of questions as well. So thank you so much, and we'll go ahead and get started here. So let's start with the big one. What the heck is a guardianship? So guardianship is a court action, and its goal is to put somebody into the decision-making role to be able to make decisions for that person about health, housing, and education. You basically step into the role as a parent would to a minor child. So whether the guardianship is over your developmentally disabled child who's turning 18, or you have a parent or a spouse who had a stroke or has Alzheimer's, and you need to be making health, housing, and education decisions for that person, adult guardianship is the same regardless of how old the person is once they turn 18. So again, whether they're just turning 18 or they're 25 or they're 100, the process is all the same. And it does take away some of that person's constitutional rights to be able to make those decisions. But that is what guardianship is about. So there's a whole lot of paperwork that goes along with being the guardian, and there will be a live hearing. In Arizona, we are required to have live, they're virtual, but they're still live hearings to provide information to the court. There'll be a court investigator as well. We're going to go through all the new people that will become part of your life as part of the guardianship proceedings. So when I say you're going to be investigated, it's a court investigator. It's not as if in most cases that you have to provide fingerprints or criminal background checks or anything like that, but it's an opportunity for court staff to have a discussion with you and make sure you understand your obligations as well as your rights. And of course, the person over whom you believe a guardianship is required has that opportunity to object. They will be appointed their own attorney, and they can let their own attorney know what they want, what they think is appropriate as part of that proceeding. So somebody may need a guardian if they have some kind of, as I said, a developmental disability, a mental illness, physical illness, alcoholism. Maybe it's just due to age-related dementia. They're just having a difficult time making these decisions, and they don't have a healthcare power of attorney that's working, or the person they've nominated is not willing to serve as their healthcare agent. That person is, disabled themselves in a way that makes it impossible for them to help. Maybe that person isn't a close friend or family member anymore, and other family members or friends think that they would be a better decision maker. And so at that point, they may have to file for guardianship to sort of almost like to substitute in for that healthcare decision maker, but they're going to go through all the same steps that are required as part of our guardianship. So these again are just some examples of when folks might need to have a guardian. These might come up again in a traumatic brain injury situation, again, where there is either inadequate or no estate planning documents for us to have somebody to make those kinds of decisions. So ward isn't exactly my favorite word, but that's how the statute defines the person for whom a guardian is needed. Sometimes referred to as the protected person, although that's mostly in our conservatorship statutes, which we're going to talk about as well. So whether I say the ward or the incapacitated person or the alleged protected person, that all means the same thing. That is the person who requires assistance in making these kinds of decisions. So what happens to this incapacitated person? So that would allow the guardian to make those medical decisions, talking to the physicians, getting HIPAA-related personal information about that person, consenting or not consenting to surgery or treatment, making decisions about medications and caregivers, also about placement. You know, should they go into a memory care center? Are they safe at home? Should they be in an assisted living center? What are those decisions that need to be made to keep that person safe? The question about driving privileges and a right to vote is specific in our statute. So if that person, even though incapacitated, if the doctor says that they have the capacity to attempt to get a license, then the court can still allow them to keep their driving privileges. And that doesn't mean they get a driver's license when they go to court, right? So if we have a developmentally disabled young adult and we say that we want them to retain their right to drive, what that means is that their driving privileges are not suspended. If the driving privileges are suspended, the order from the court actually goes to the Department of Motor Vehicles. So if the person were to apply for a license, it would be denied because their driving was suspended by the court. That doesn't mean that later on you can't get those rights back. So maybe as time goes on, that person matures, or maybe they had a stroke and now they're better, then we might terminate the whole guardianship, or we might go back and say, hey, here's a physician's letter and the person's been doing this driving class and this shows that they really do have the competency to get their driving privileges back. And we can then apply to the court and have those driving privileges reinstated. For somebody who already has a license, maybe what we want to do is make sure it doesn't get suspended, that they can keep their driving privileges. And so again, we would put in the petition and in the order that they can keep the driving license that they already have and those privileges. The same is true for the right to vote. It's a higher standard for the court, so we need a doctor to be very clear in that physician report that the person has the capacity to vote and to not be swayed, not have undue influence by those around them, but that they specifically have the ability, the cognitive ability to vote. I used to joke with the court that, you know, the confusing part about ballots, and you hear something on TV about one candidate versus another and trying to sift through what's real and what's not real. And if you vote yes for a ballot decision, are you saying you want it or that you're saying you don't want it to go forward? So sometimes I'm not even sure I'm competent to vote when I look at all of that stuff. But of course, we're all thrown in there together. So as long as the doctor says that that person has the competency to vote, they, just like any other adult, would retain those privileges to do so. So as I said, there are a lot of documents that are required in order to do the guardianship. We call court documents pleadings. Again, just a term of art for you to understand if you see it somewhere. And you also have to make sure that you get the documents into the court in the right order with the right number of copies of everything. So the courthouses are currently open during COVID. All of our hearings are done virtually on a program called Court Connect, which is a Microsoft Teams product. But you do have to file your documents, whether you use a process server to do that or some other service, or you individually go, or of course, if you hire the attorney, then they would make sure that the documents are filed appropriately. If you are filing for somebody who is indigent, that is, they might be receiving SSI benefits, supplemental security income. They might be on All-Tex benefits, our long-term Medicaid program, or they don't have, you know, they have very limited income and very limited assets. If that were the case, you would want to make sure that when you file, you ask for that fee waiver. So the fee waiver is the document for the court where they would defer the court filing costs and any of the fees associated with the action until the court can just make the decision and either waive all of those fees or say that they need to be paid. It's very difficult for the court to go back afterwards and issue a request for a refund. So I encourage you, if you're doing it on your own, that you make sure you file the request for the waiver at the same time. The court has a great self-service center. So it's right on their website, on the Superior Court of Maricopa County website. All of the documents that you need are there, along with the instructions. Again, you have to make sure that you do all the things you need to do that are in the instructions, including getting a hearing set for the date, as well as getting court-appointed counsel appointed for your case. So when and why, we talked a little bit about this. As I said, an incapacitated person, as long as they are 17 and a half or older, you file the guardianship in the probate division of the Superior Court. If they are a minor and we don't have any money at issue, we don't need a conservatorship to be appointed, you would file in the juvenile court. So I'm talking about matters in the probate division for adults, but you can file as early as 17 and a half, and it will go into effect when that individual turns 18. As I said, sometimes we have healthcare power of attorney and we don't have somebody who's willing to serve, or they're not an appropriate party to serve, or we can't find them. In Arizona, we also have a specific statute regarding inpatient psychiatric hospitalizations. So if sometimes we need to have a guardian appointed because the person has been admitted to a psychiatric hospital or needs to be admitted to that psychiatric hospital, and they don't have what we call a mental health power of attorney. So this is sometimes the reason we have to do the guardianship, is because we need that extra authority that doesn't exist. Even if they had an estate plan, it didn't include that mental health authority. And of course, we might have an uncooperative incapacitated person who, when you go to the doctor with them, tells the doctor not to talk to you. And so they can override their healthcare document, their healthcare power of attorney, but not a court order. So if you are the guardian appointed by the court, you have the right to make all of those decisions regardless of how uncooperative your loved one may be. And sometimes you need a guardianship because you need to do placement into a long-term care facility, whether that's a group home or an assisted living center or a memory care center. Again, and you have an uncooperative person, that court order should help you get them transported where they need to go, as well as admitted without anybody charging you with kidnapping for them. So just something to think about as some of the reasons. So can I say it again? There's a lot of paperwork. So I've sort of broken out what the various requirements are. So kind of the list of the things you need to do to start your action. And again, make sure you do all of the documents if you're doing it on your own. And then all the things that have to be filed before your hearing, which you can file at the same time you do your first filing. So you can file your probate cover sheet and your petition and all of the rest of that stuff, and your physician report, your health professionals report, and your notice of hearing, and your waiver, of course, to make sure on the fees and the orders that the court's going to need to sign. You can file all of that whenever, at the beginning. The orders must be filed with the court with copies to the commissioner's division no less than 5 days prior to your hearing, or the commissioner can tell you they're not going to hear your matter because they didn't have an opportunity to review the orders in advance. Something called your letters of appointment and your acceptance, which we kind of talk about as your walking around papers. That's the document that you would provide to doctors and hospitals and educators that show that you were appointed. The commissioner doesn't sign off on those at the hearing. Those get issued by the clerk of the court. So after the hearing is over with, and once your orders are issued, then the letters of appointment are issued by the clerk. And I know that it's a lot of information. I just want you to sort of understand that there's a lot of moving parts, and all of these documents need to be filed in the right order, but the letters of appointment are kind of your last step to make sure that you have the authority to make the decisions that you need to make. So Anybody can be appointed who has an interest in that person. The statute has a list of priority. The court doesn't have to go by that priority. So we might have two spouses, both of whom are incapacitated and neither of whom are recognizing their incapacity. And so maybe a child is going to be the one to petition to become the guardian, even though they have a spouse. Sometimes a parent isn't the appropriate person, even for our younger folks. So maybe that's a parent who there's an order of protection against because they've been abusive to that child. And now as the child is approaching age 18, we need to file for guardianship. So maybe that isn't the right person. Or the individual lives with a sibling. And so maybe that sibling is the one who should be the one who's appointed as guardian. So they have a list of priorities, but that isn't necessarily the order they're going to go in. We have to base it on what the facts of the and circumstances are for the individual. There is an affidavit that has to be filled out by the person who's going to be appointed or wants to be appointed by the court. And if there's a recent criminal history, a violent history, unlikely that the court is going to appoint that person to be a guardian. Same thing if you have a history with the Department of Child Safety or Adult Protective Services for elder abuse. Again, unlikely you're going to get appointed. But I have had people appointed who maybe had a financial crime that was some time ago and isn't related to their loved one. And it isn't about who can make health and housing decisions. They might not be the perfect fit for the court for a conservator, which we're going to talk about, which is over the money. But maybe guardianship is fine. So it doesn't rule you out, but the court will need to know that as part of the affidavit that has to be completed. So I've talked a little bit about each of these people. The incapacitated person will be appointed an attorney by the court. There will be a court investigator who gives you a call or does a FaceTime call with you as well as the person over whom you would like to become the guardian. And that court investigator is going to put in the report exactly what you say. So be truthful, but be conscientious. So if you hate your spouse and you say, well, I'm applying to be guardian, I don't want my ex-spouse to be the guardian because that person is a terrible person and they owe back child support and they're mean and they call too often and they've been harassing me, understand that as part of our notice provisions, we are required to provide notice to the parents of the person who are alleging to be incapacitated, and they may get a copy of that court investigator's report, and it's part of the court record, which is part of that court investigator's report will be public. We need a health professional who doesn't necessarily have to be a physician unless we need mental health authority, in which case it must be a psychologist or a psychiatrist. And then, of course, you, the overwhelmed person who's trying to get all your paperwork done. Court investigator is court staff. As I said, they're going to interview and make a recommendation to the court as to whether you seem like somebody who's an appropriate person to serve, whether there are any other issues that the court should be aware of that they may have been raised during that court investigation. Usually the court investigator and the court-appointed counsel are going to reach out to you or the person over whom a guardian is being requested, usually about 2 weeks prior to the hearing. So don't panic if you haven't heard from them for a while. And again, they're doing all of those by virtual or over the phone instead of in person. The court-appointed attorney is an attorney. Their job is to do what the proposed protected person wants, so they will object. Their job is not to look out for the best interests of that person. It's to be their advocate. So if you have an uncooperative loved one who you are trying to get guardianship over, they may object through their attorney. That doesn't mean you lose, but it does mean there may be an objection and it may require a second hearing. And you must call the Office of Defense Services to get that court-appointed counsel. We don't get to pick them even as the attorney. So you have to make sure to call if you're doing it on your own. And again, if you don't get the court-appointed attorney prior to the hearing will not go forward. It's a statutory requirement. Health professionals report is the document that helps the court understand what the needs of this person are, where they should live, medications that they're on, what their diagnosis is, whether they agree that a guardianship is actually needed. Again, if we need inpatient mental health authority, it has to be signed by a psychiatrist or psychologist. Otherwise, a nurse practitioner, the physician assistant, all of those other folks are fine to fill out the health professionals report. And some of these people do charge for the report and some don't. The court has a form. It's a fill in the blank, check the box. It should be pretty easy for the health professional to complete. And they'll have to do that each and every year at the time of the annual report of guardianship. Notice has to be given with the documents, personal service on the person who you're claiming to be incapacitated. So you can't just hand it to them. We have to have a process server do that so that we can get an affidavit that they were served. If they show up at the hearing, then usually that's enough notice. But we do want to personally serve them in case they're sick that day and unable to even be on the video, and to prove that they actually got all the documents they were entitled to. There are other folks who are entitled to notice, so we want to make sure everybody who's entitled to notice gets appropriate notice. The commissioner will look through the file in advance to make sure that everybody who is entitled to notice gets notice, and then we have to file a proof that we actually gave it to those people. So again, process server for the incapacitated person, and typically the parents, if they're living. If we don't have living parents, then we need to get it to the closest relative. Sometimes we can do certified mail, particularly if the person does not reside in the state of Arizona. And sometimes we will serve the person and then have them sign a consent that in fact they received it and they're consenting to the proceedings and they don't have any objection. But again, always the incapacitated person, the spouse, the parents, and the adult children all are entitled to notice. And sometimes we don't have any of those people. So then we have to look at who were they living with, who's the closest relative. There's a hearing set in every single matter for these cases. If it's not an emergency, hearings are set typically about 4 to 6 weeks from the time we file. And remember, we have to give 14 days notice. So between filing and getting the notice out and making sure the proof is filed with the court, we kind of need a little bit of time in order to get all those things done. If you have an emergency, we can typically get the hearing set within about 5 days. If you have an emergency, it was that we could go actually sit in the courtroom and wait to be heard. Now we would have to call the judicial assistant, let them know we have an emergency that needs to be heard immediately before we even got to the point of having the court set it for a hearing date. Sometimes the judge will just sign the orders based on the pleadings that are submitted, but sometimes we need to actually ask to be heard immediately without notice to anybody, and then we would go back and do all of our notice requirements. That guardianship, again, as I said, is not valid until those letters of appointment are issued. We can get certified letters, which are $30 each, unless the person was indigent. The court sets these internal compliance hearings, and I tell you that because after a hearing, you're going to get something called a minute entry, which is kind of the court shorthand for what happened. And they're going to say that there's a compliance hearing set to make sure the letters were issued. As long as everything was done properly, you don't ever have to attend those compliant hearings. They're really an opportunity for the court to make sure that what you said you were going to do, you actually did. So that's what they're for. And if you didn't do it, you do have to show up at your compliance hearing and explain to the court why you didn't do it and when it is you can get it done, so you don't keep getting in trouble with the commissioners and the judges. If all your paperwork is correct and everybody's agreed, there are no objections, your hearing's probably going to last about 10 minutes. But understand that the court may have 3 matters all set for that 9 o'clock time slot when your hearing is occurring. So it might be 40 minutes before you're heard, even if you have an uncontested matter that will only take a few minutes. The guardian always has to testify. I tell people the only part that's like TV is that the commissioner will have the person raise their right hand to swear to tell the truth, the whole truth, and nothing but the truth. Other than that, it's not like TV at all. So as long as everybody's getting along, We can ask leading questions, meaning you can just answer yes or no. The rules of evidence are much less strict in an uncontested matter in the probate division. So pretty much you're just agreeing and confirming that what was submitted to the court is still true and correct and that you understand what your obligations are. There is a mandatory training, and it's for any probate matter. So we have training for guardianship, training for conservatorship, training for personal representatives. I would encourage you to go to the website and watch the trainings if you think that you may need to be the guardian or conservator for somebody. They're pretty well done. They're all about 20 minutes long. They're free. You're going to have to do it and sign the certificates at the end if you move forward. So I think it's a really good overview of what a guardianship is about. So I would definitely encourage you to watch the videos. As I said, make sure you file that waiver or deferral of fees at the beginning. And your health professionals report has to be filed as a confidential document, which means it goes in just a typical brown envelope marked that it's confidential. And so that the purpose of that is to make sure that, of course, nobody else can see, and to make sure that it stays confidential because it's important information. And when possible, we would like the incapacitated person to attend the hearing. Oftentimes we'll see them sort of put their head in the video these days, and the court just says, "Oh, is that Joey?" And we say, "Yes, that's Joey." And the court says, "Terrific, glad to have you here with us." So make sure to take a look at that. Guardians decide where your incapacitated person is going to live, but it must be the least restrictive environment in which that person can be safe. And they, of course, have the authority to consent for treatment. And they may be able to institute legal proceedings depending on what the legal proceedings are about. That is, what's the topic. You have to do everything you can to maximize that person's independence. So I talked to lots of parents who have developmentally disabled children, and they're very concerned, obviously, about taking away rights from their kid who they've done all this work to try and help them be independent and be respectful of what their strengths are. So even if you do a guardianship, again, your job is to maximize their independence, to help them reach their potential. And if they don't need a guardian in the future and we have a physician who agrees, we set it for a hearing and ask for the court to terminate the guardianship. So even though it's called a permanent guardianship, it can be terminated. It can be limited later. So again, that we give somebody now the right to vote or to drive or other privileges that were taken away as part of the guardianship. You have to take into consideration what that person's wishes were, where they wanted to live, who they wanted to be close to, maybe who they wanted to visit them or who they didn't want to visit for them. So your job, again, is to think of yourself as that parent of a minor child where you're doing everything you can to make things better for that person and keep them safe, regardless of whether they're your 20-year-old child with Down syndrome or they're your 90-year-old parent. So the rules are the same. Again, I stress this mental health authority because we do get calls, panicked calls of, I have a healthcare power of attorney for my dad. He was just transferred to an inpatient psychiatric hospital. They're telling me my paperwork isn't good enough and that if he wants to leave, he can. They can only hold him for 48 hours and then they have to let him go. And so sometimes we have to do an emergency guardianship so that we can have this mental health authority. That is the ability to put somebody in a locked behavioral health care hospital. This is not an Alzheimer's unit. It has its own licensure as a behavioral health care hospital. And the physician report, that health professionals report, must specifically state that they require this hospitalization with great probability in the next 12 months or right now. And that authority only lasts for 12 months. So if we have a person who has mental illness, every year we just renew the mental health powers. Your guardianship would stay in place. We don't have to renew that each year, although you do have to file a health professionals report and an annual report of guardian, but we don't have to renew that like we do this extra power, so to speak. So every year we would have to file a new health professionals report done by a psychiatrist or psychologist that again says that person is in great likelihood of needing a hospitalization in the next 12 months. Also, we want to make sure that gets done timely, because if we don't get it done on time, we have to now file a new petition to get it reinstated, which is a much more complicated, expensive process, as you can imagine. So again, voting and driving can be rights that the person keeps. If there are other rights you want them to have, I've never been creative enough to come up with other rights, but if there are, we can ask for the guardianship to be limited as well. And again, they don't have to get both. We have some folks under guardianship who can vote, but they don't have a driver's license, or vice versa. You have to keep the court apprised as to your address and the incapacitated person's address. We have only 3 days to report a permanent change of address for the person who's incapacitated, and 10 days to report if you move. If the person, you go on vacation, when we can do that again, you don't have to report that to the court. If there is a hospitalization, we don't have to tell the court about that, although we might have to tell other interested parties. If they go into a psychiatric hospital, we need to tell their court-appointed counsel that they've been hospitalized, when they were admitted, and where they went. And then, as I said, every year you have to file your annual report of guardian and your health professionals report. And any name changes, people get married, the guardian maybe got married, we have to report a name change, or the death of either our guardian conservator or that incapacitated person. So sometimes these things don't happen as quickly, because obviously these are major life events, but it's important to let the court know if the court investigator has a right to come back and re-interview you at any time. If they go to interview you and they can't find you, that is not good. They will report that to the court. If the court sends you a notice and it gets returned to the court, that is not good either, and the court will do everything they can to figure out where you went. And so keeping them apprised proactively is always the best approach. So the guardian is not a person or an entity that handles money over $10,000. So you might need a conservator, which we're going to talk about less, if the incapacitated person's assets are more than $10,000, or they have income maybe that puts them over the limit and you are not the representative payee for Social Security. So Social Security, as many of you may know, has its own process for who gets to manage the Social Security income, and that's their representative payee process. You could be the guardian and the rep payee, but you don't have to apply to be a guardian to be the representative payee. You can do that separately. Although we have found from some parents that it's been easier for them, for Social Security, to appoint them as the representative payee when they did the guardianship, and they were doing the guardianship when that child turned 18. And so they were going to start their SSI benefits at age 18 anyway, so they did it all as one proceeding. The guardian may also be the trustee for the incapacitated person, but you don't have to be appointed as the guardian to be the trustee. If you're nominated in the document, then the court doesn't typically have to have any say-so over that. And you're going to find out here in a couple of minutes about why you wouldn't just want to file for the sake of it to be the conservator, because there's more paperwork and more details and accountings and all this other stuff. I want to touch on this for a minute. You can nominate who should be the guardian over your incapacitated child, adult child, or a spouse. So you can do that in your will, or you can do that by separate writing. So that's a really good way to make sure you have a succession plan, because we don't have backup court-appointed guardians in Arizona. If you're the guardian, you're the guardian. You aren't just the guardian if the person who you think of as the primary caretaker became ill or passed away. If you're on the orders of guardianship and letters are issued with your name on them, you have all the responsibilities of being a guardian. So if you want to have a backup plan, again, you can nominate a guardian in a will, or you can do it by a separate writing. And it's a pretty straightforward process. The new guardian would file the copy of the will or their separate nomination and a couple of pleadings for the court to be appointed right away so that we don't have a gap in time. And then thereafter, we would give notice and have our hearing and do all of the things that I've been talking about. So it's a pretty streamlined process to make sure we don't end up with a gap in time when we have an incapacitated person. So that's the guardianship process. I always feel like I start off slow and then I have to rush because I keep looking at the clock thinking we have a lot of information to talk about and we still have guardianship and alternatives. So let me see if I can figure out, oops, not that. There we go. Okay, so we have a couple of questions. So let me see. I don't know if that's on your screen, Linda, that you see. So can remote court be done post-COVID, out-of-state kids, witnesses, whatever? So from everything we've heard from our commissioners and judge in our probate division, I believe that they will continue with our remote court process for all uncontested proceedings. So that even if you live locally, I don't think you'll have to appear in court, at least as far as I can see, future. They have this Court Connect system. It records just like as if you were in the courtroom. I think their intent is to keep that for our uncontested matters and only open the courtroom in the future when we have objections or trials or contested hearings. So I think that's how that will work. And another question is whether we have to give notice to all the adult children. The answer is yes, all the adult children, including we have times when we have incapacitated adult children and we still have to provide notice. And as long as there isn't an objection, then it's not a problem. So one of the questions is whether you'll be able to view the program. Somebody may have come in a little bit late. Or maybe I started a little early, I don't know. But yes, we'll have these webinars up on our website so you can check them out anytime. And I think that we have a YouTube channel that they'll go on. So yes, anytime you can look at them in the future. Question about, does the attorney have a duty to the court to reveal adverse information and contested things and all the rest of that? And the answer is of course, although if somebody has behind the scenes said, hey, I don't like the fact that this is happening, but they don't show up at the hearing to contest the matter, then it's not my obligation to tell the court that somebody's unhappy we're doing it. It is that person's responsibility to bring forth what their concerns are, unless we've reached some kind of an agreement, such as, you know, Joe Smith has an objection. He just wants to make sure he's going to always know where the ward is living, and we've agreed we'll keep him on the notice list. Then sure, that's not a problem at all. Right now, even contested matters are being done remotely on our Court Connect. I think, though, in the future, post-COVID, those will go back into the courthouse. Let's see if we have some more up here. What's the process for when looking for a public fiduciary for a person who doesn't have any family or a designated mental power of attorney or healthcare power of attorney? So the goal would hopefully be that if the person's in an institution, that the institution, whether it's a hospital or some other placement, would file the petition to nominate the public fiduciary in the appropriate county. We, in my office, I've represented some of the local hospitals for just that purpose. They have somebody in their facility. There's no family that they've been able to locate or any estate planning documents. From the time the guardianship paperwork is filed, how long can it take before the guardian is appointed? As I said, on a routine matter, that is where we don't have an emergency, usually somewhere between 4 and 6 weeks, and they're typically appointed at that initial hearing. The courts have been fantastic about getting the orders in their outboxes by the next morning so that our runners can pick them up and get the letters issued. So they're basically appointed that same day. The authority would start the next day once they have their documents. If someone is mental health power of attorney for an incapacitated person without any alternates, does guardianship need to be established first before naming an alternate in case the living spouse dies? So I would always say that if you're doing estate planning, you want a backup plan. So don't just have one person as your successor agent under a financial power of attorney or a healthcare power of attorney or a trustee. Have a list as long as you have people or entities that you would trust to be in that role. But if we don't have an alternate and the person is no longer competent to sign a document to name an alternate, we might be here in the guardianship proceeding for sure. Can you speak to when a patient is on hospice, there's no family, no funds, the best way to explore guardianship? So somebody has to file a petition. So it's going to take some effort on somebody's behalf to do that, whether again it's the institution. It's possible if there's abuse or neglect that Adult Protective Services may file or may hand it over to the public fiduciary, and then they would file on behalf of that person. If you are a professional and have indigent residents in your facility or on service at your communities, I would encourage you to reach out to the public fiduciary in your county and talk about the best way to get them appointed in the event that an appointment is needed, so you can understand how best to process that information. Let's see. Oh, the cost of the guardianship, the court-appointed attorney, all that sort of stuff. So the answer is that the filing fee and court investigator fee, I think, are about $800 in Maricopa County if you don't get those waived because the person's indigent. Court-appointed counsel, again, if the person is not indigent, those fees are probably going to run in the 2,000-ish range if there are no contests. And you can certainly call our office about fees. Uncontested guardianships we do at a flat fee of $3,750. That's from start to finish. So it just depends. Other attorneys may be charging hourly or have different flat fees for those things. It's about, as I said, $30 to get certified orders and certified letters. If you have all three of the powers of attorney, that's mental health, financial, and healthcare, do you have to do a guardianship for a spouse? And the answer is you shouldn't have to, as long as those documents are validly signed. Sometimes we see healthcare documents with no witnesses. Sometimes we see financial documents with no notary. So as long as they were appropriately signed, they should certainly work. The comment is about when they had to refinance the house and the spouse couldn't sign, they had a power of attorney and the title company still required the spouse even just to make a mark. If I could figure out why title companies decide some things are okay and others aren't, I would be a millionaire. Same with banks who decide when they want to accept powers of attorney and when they don't. I mean, they're valid, they should certainly work. And so there's no rhyme or reason sometimes, unfortunately. Somebody's saying that they have a child who's almost 18 and they're not sure whether they want to do guardianship. It's a great question, and I would strongly encourage you to talk to the child's physicians and educators about how they think that person would be competent to make those choices. I'm, of course, happy to consult with you as well, but we really rely on the physician to give us the report to support the need for the guardianship, remembering again that you can terminate it at any time. The documents are available on the self-service website if you don't have the funds to pay for a guardianship. We also have, through the Maricopa County Bar, has a program where they can hook you up with an attorney at no cost who's on their panel. They're practicing attorneys. I'm on the panel and take cases occasionally to do pro bono work. So, and you can call our office at any time. We're happy to get you that contact information. Let me just make sure I've answered all the questions so that I still have enough time to talk about conservatorship and other options. Where is the public fiduciary list located? So you can Google, if you know, by county, Maricopa County Public Fiduciary, Yavapai County Public Fiduciary, and you should be able to get contact information for each of the public fiduciaries. We also have licensed fiduciaries. Those are private individuals or companies. That is for private pay, not for your indigent clients. But if a person had money, but they don't have family willing or able to serve, or they don't have any family, then a private licensed fiduciary is often a really good fit for that person. Is it a myth that the public fiduciary would not be willing to work on guardianship for a hospice patient due to their limited life and prognosis? I, again, cannot predict when the public fiduciary is and is not willing to take cases, but I would encourage you to call their office and find out and give whatever details you need. If somebody is in need, even if they say that they're going to object, is not a reason not to file a petition, because it's up to the court. All the public fiduciary can do is object to the appointment, but the commissioner gets to decide whether or not they're actually going to get appointed. Okay, we're going to do conservatorship and other options in our last bit of time here, to be respectful for other things you have to do with your life. So conservatorship is so you can manage the finances. And thank you so much for all those fantastic questions. I really, really appreciate it. So conservatorship is to manage assets for an incapacitated person. So maybe you need to sell a piece of real estate or a house. You need access to a bank account, or you need to talk to the utility company. You might need to redirect the income into the account that you're able to manage, sign off on the check, or set up electronic banking. All of that is for the conservatorship. Again, if the amount of money is over $10,000. So that's when you might need a conservatorship. Again, if the assets aren't in a trust, or the trustee isn't doing the right thing, or you didn't have a financial power of attorney, or the agents listed in that financial power of attorney, sometimes called a durable power of attorney, is unable or unwilling to act for the benefit of that person. So everything I already told you about guardianships is true of conservatorships. So you have to file your petition, you have to have a hearing, you have to fill out your affidavit, you have to get court-appointed counsel, you have to get a court investigator. Plus, we have to get a bond for any assets that are going to be unrestricted. That is, money that you will have access to has to be bonded, meaning that you have to have enough money so that the bonding company will issue a bond on your behalf. Any money over the bond amount would be restricted. You have to provide annual accountings to the court, and they have to balance to the penny. Every penny in, every penny out, and we provide the source documents so the court knows we're telling the truth as to here are the bank statements. We have to file a credit report for that person along with an annual budget. So the annual accounting and the budget needs to be done every single year. And budgets actually need to be updated if you budgeted for a category like caregiving, let's say. If the amount turns out to be more than $2,000 or 10% of the amount you budgeted, that is a tiny little window to fit through. So you want your budget to be as accurate as you can, so you don't have to spend time and money to file an amended budget. For conservatorships, my understanding from the bonding companies is you would have to have an attorney, because they won't bond you if there's no attorney, because their thinking is that things will be done correctly and it's less likely that you will misuse the money if you had an attorney who was helping you to understand what your requirements were. Again, if you're the rep payee, you don't have to be a conservator, because if the only thing you need to manage is Social Security, again, through that representative payee process. If you're managing money from the Veterans Administration, they have their own fiduciary process, and they'll do an interview, background checks, and typically you have to segregate out funds that are coming from the Veterans Administration into their own account. So again, that may not require a conservatorship through the court. And if you hold your accounts jointly, you have access to them. Typically, you're not going to need a conservatorship. Again, normally we only need the conservatorship when we have assets only in the incapacitated person's name, and there isn't a power of attorney, or the assets are not in a trust, is when we need to deal with the conservatorship. The other time you might need it is if you're going to sell real estate and you don't have a financial power of attorney, even though it's held jointly, you're probably going to need some order from the court, or the title company isn't going to close the deal. We have something called single transaction authority, which I think is a little misleading because it could be for more than one action, but really that it's a limited time scope and limited actions that you need to handle. So we've done these when we need to get a reverse mortgage, maybe to pay for care or pay off debts. So we go to court and we ask for the court to give us that specific authority, or maybe to fund a trust. So the trust was drafted, but the accounts aren't titled correctly. So we need the authority to take the money or the assets that are in that incapacitated person's name, retitle them into the trust, or occasionally to establish or appoint a trustee of a special needs trust. If your incapacitated person moves out of the state, we have to petition the court to tell them that we're transferring the guardianship and get approval from the state where the person's going. Same for conservatorship, but a conservatorship, we're going to have a hearing because we have to figure out bond and accountings and all these other things. For guardianship, like I said, pretty easy process, kind of less easy for the conservator. Also, if there's mental health powers, we're going to have a hearing for that along with the conservatorship. So let's talk about some alternatives. Too much talking. So here are some alternatives. Our powers of attorney, of course. So healthcare powers of attorney are to allow somebody to make healthcare decisions, as you know. Healthcare power of attorney in Arizona can include the authority about organ donation, and you can have your preference as to whether you want to be buried or cremated set forth in your healthcare document. That's the one power that after you pass away, the healthcare agent would maintain. Again, if you've set it forth in your healthcare document about organ donation, cremation, or burial, so that they can authorize that. Remember that a power of attorney can be terminated anytime. So if you may need a guardianship, if the person then wants to terminate that power of attorney, whether it's health or mental health, so they, you might still need a guardianship. Also remember that the person has to be competent. If I could tell you how many times we get a call to tell me that mom just had a stroke and she can't speak and she's in the hospital and we don't know that she's competent anymore, can I come to the hospital so that I can get a power of attorney done for her? You are past the point, unfortunately, of doing estate planning at that point. We are going to be in front of the court if you need decision-making authority. Also remember that Arizona has a surrogacy act, a healthcare surrogacy act. So if you are the spouse and you need to make decisions for your spouse for healthcare other than admission to a mental health facility or removing the ventilator or feeding tube, you can make those decisions without a healthcare document. Now, if there's fighting within the family, you might still need to go to court and have somebody be the guardian. If everybody's getting along, or if there's no spouse, the children of that person would have the ability by majority decision to make those decisions. Definitely not perfect to rely on the Surrogacy Act because it doesn't name a person, doesn't give us authority with regard to the burial and the cremation. It doesn't give us a lot of what we get in a written document, but it is a backup plan if the person is now incapacitated. You may still not have to do the guardianship if all of the decisions can rest on a person under that healthcare surrogacy. I want to talk a little bit about supported decision-making before I take the questions that I see have come up. So there was a proposal in the legislation to make this part of our statutes. What it is an alternative to guardianship where the individual basically signs a contract, chooses who their supported decision maker or makers will be, says what they can help the person make decisions about, promotes self-determination, but the statute says that as the supported decision maker, you cannot make the decision for them. All you can do is provide guidance. You cannot sign legal documents on that person's behalf. Again, all you can do is provide guidance. So maybe it says it would allow you to get HIPAA related information about the person, but you don't get to make the decisions. So while I think it may have a place in our statutes in your life, I think you're going to have to think about it long and hard, because if the person's competent, they should be signing estate planning documents. If they're not competent, you're probably going to be in front of the court to make decisions if you didn't have those estate planning documents in place. And if you have a cooperative, competent adult, then I'm not sure why they need a contract to tell you you can help them make decisions. So I'm a little skeptical, but we don't have legislation that's passed, so we haven't seen it in play. Again, I think it's a great, if nothing else, it's a great way to remind us that the goal of all of this, estate planning, guardianship, conservatorship, whatever it is to promote self-determination, control, and independence, and respect in every adult who should have the authority to make decisions that are in their best interests and meet their goals. So I just wanted to bring it up because it does come up fairly, I would say infrequently, but people do ask about it. So I think it's important for you to understand what it's about. So that's my material, but I know we had some questions. So give me just a minute to see what else we have. The question is, was supported decision-making legislation passed? And my understanding is it has not passed, but you can certainly check out the draft legislation, but it is my understanding that no, it has not passed. If I said that in a way that wasn't as clear the first time around. And let's see what we have over here. If a disabled person is in a different state as the guardian or conservator, what would the process be? So the answer is that the court in Arizona cares about where the incapacitated person is, not where the guardian or conservator reside. So if your incapacitated person lives in Arizona and you live in New Mexico, you can still be appointed as the guardian and conservator in Arizona. The court is just going to be concerned that you are going to take your job seriously. Because if you're the guardian, they don't have to live with you, but you need to stay on top of things to make sure that they're safe, that they're in an appropriate location, that you talk with them on enough of a basis to know that that's true, that you speak with their caregivers and whoever else is there to support them. If you move, we have to let the court know that you've moved with that change of address, but you don't have to live in the state here. If that person leaves the state of Arizona, then we have to do the action where we transfer that matter. This person is under the impression that when somebody dies, the medical power of attorney ends, making funeral arrangements fall to the family as a unit. If your medical power of attorney says you want to be cremated or buried, your agent under the healthcare power of attorney or medical power of attorney has the authority to complete that portion of the decision making. If it doesn't say anything, then yes, the family would have to together come up with that decision and work with the mortuary to make sure that the mortuary feels comfortable that they have the right decision makers. You can't really uncremate somebody, so they want to make sure they have the right people. But if you've given the authority in your healthcare document, you've given the authority to your agent to make those decisions. Typically, we write the medical power of attorney to include the ability to have a separate written document with instructions. So maybe you've said you want to be buried or cremated, and you want your cremation to be, your cremated remains to be buried at a specific cemetery or given to specific people or spread at a specific location. So all of that can be in your medical power of attorney or as a separate document. Can I speak to the hierarchy about what supersedes what? So guardianship typically will supersede your healthcare power of attorney. And in fact, in the documents we prepare for the court, we make that explicit, that it is revoking the healthcare power of attorney that may be out there or ones we don't even know about. If there's a mental health power of attorney and we didn't need inpatient mental health treatment through the court, we may say specifically that the mental health power of attorney signed on such and such a date remains in full force and effect. So you can, in some ways, determine the hierarchy by how you do things, but the guardian will typically always have a higher authority than a healthcare power of attorney, and typically that guardianship is going to terminate that healthcare power of attorney. Same thing on the money. We may need a conservatorship over one specific asset, and so we would say that the financial power of attorney is still in effect over everything else, but we needed it to sell the house. And maybe we're going to terminate it after the house sells because the money is going to go into an account that the agent can then manage. So you just have to lay out in the petition what it is you want, and then the court can make the determination about what it is that makes the most sense. So kind of a follow-up question on the funeral for that power, that is the burial or cremation. Does it have to state what they want, i.e. burial, or can it just give them authority to choose? It can be either. So you can say that you want to be buried or you want to be cremated, or you can just say that the agent has the authority to make that determination. Can I clarify the mental health power of attorneyship and guardianship? So typically when we do the guardianship, if they need mental health, if the guardian needs mental health authority, we're going to do it all as one proceeding. I can't think of a time when we didn't. We have had to do a guardianship because a person didn't have a mental health power of attorney, but they had a general health care power of attorney. So we needed just the mental health authority. Sometimes though, we've just done it all as one, even when they had a general health care power of attorney, because it requires the notice, and the concern was if they needed the mental health authority, probably they weren't going to be cooperative with other decisions, and so we needed a court order for the guardianship anyway. So typically those go together, but they don't have to go together. There's no requirement that you do both of them. You can have a general guardianship, obviously, without mental health authority, which is 9 times out of 10 what happens, or you can have both of them. So I want to say so much how I appreciate you all showing up today and asking phenomenal questions. I wish that I could see you and give you a big hug. I hope that you are staying well and healthy, and we're always here to answer your questions. We're here to be a resource either to you or those of you who are professionals who may need not an attorney but some other service provider. We're always here to answer your questions. So again, I'm Emily Kile, and we look forward to the opportunity to serve you. So thank you so much and enjoy the rest of the day.